Bill Henshaw here, Constitutional Crisis Channel. Lots of new videos for you, and we just put some up pretty recently too, so check those out in the last 10 days or so. These will be going up mid-May, whatever. And I've got some news out of what I call my Merced 2 case. I might be calling it later Miracle in Merced Part 2. These people are so damn stupid out there that I've got a friend of mine that's been using my materials and filing them. He filed all the basic documents that I advise all of my people to file that I send out in my document packets. You know, you got a bill of particulars, a motion to dismiss, brief on the 14th Amendment, denial of counsel, and objection to entry of plea. He files all of them, and they immediately, a judge who had never laid eyes on him before, compels him to go for a mandatory psychiatric evaluation to see whether or not he's quote unquote competent. What the hell does that have to do with the unopposed issues that he put in there and challenged the jurisdiction? And as usual, a local dumbass hasn't even acknowledged them, let alone answered them, and they never do, for those of you that are familiar with my work. 4 decades, they don't answer because they have no answers. What that means is our jurisdictional challenges are correct, and we should win the case. I would love to get a couple of wins on the record. That'd be really nice. But in traffic court, when they dismiss the cases and you go on down the road, that normally takes care of business. We'll have more to say about that in a little while. But the Merced case has gotten to the point he's had 4 or 5 hearings when the case should have been dismissed on the second hearing or even the first one. But now, I send a love letter out there, as I sometimes want to do to some of these people. I sent it out to the presiding judge, quote unquote, and suggested to him that all that was going on there, you had no factual foundation and legal basis, for a psychiatric evaluation. My friend not only didn't plead not guilty by reason of mental disease or defect, he didn't put a plea in at all because he understands, as I want to teach you, how jurisdictional it is. Once you put a plea in not guilty, I didn't do it. See ya. Now are you going to get the fair trial with an attorney? You're going to get convicted and they're going to get affirmed on appeal because you had no rights that were violated. That's how this works, and that's why this objection of entry to plea is such a potent tool, because most of the bastards you're dealing with won't even have seen this issue before, and yet I get it from the Supreme Court of the United States, like almost everything I do. That's where it comes from, the 9-0 farts. So here we are, and I sent a love letter to the judge pointing all this out and saying, you've done this. My friend never had a chance for an independent evaluation of his quote-unquote competency. Now one wonders how you could get an independent evaluation since the only qualified people with expert opinions are their own licensed shrinks. Nevertheless, that never happened. He never had any kind of a hearing in open court on this issue at all. And even though they have a statute here in California, Penal Code Section 1368, that permits them to do this, the real reason is plain as day, and it will be to an inflamed jury if we ever get these bastards in front of one in an offensive action, because all the reason they thought he was incompetent was he was asking a lot of questions they can't answer. And this is their way to get around it. And this is a big breakthrough for us because the issues I can raise out of this have an excellent chance to be before the 9-0 farts at the beginning of the next term in October of 2018. Because if they're going to have the power to say, and the report they wrote on my friend, and I'll get his permission to make that available to people that want it. I don't have that right now, and I won't do it without his permission. But the psych eval report that was written on him, that could be a boilerplate document they could use on you, me, and anyone else, that is sick enough in their mind to put in challenges to the jurisdiction that they can't answer. This is the only defense they have to it, and it's clear as hell what happened here. The 9-0 farts are going to see this. Ruth Bader Ginsburg is going to get this one. You can't do this. If we're a nation of incompetent people, what does that say about the people that framed the Constitution? And what does that say about your competence on Election Day? Not my competence, because I don't vote. I've never voted, going back even before the time I understood why I shouldn't. And that goes to the issue of the voter registration form, where you have to declare under penalty of perjury that you owe your citizenship to the non-existent 14th War Amendment. So therefore, we have no voters, we have no elections, and I'm going to have more to say about that on a upcoming video shortly with Robert Reich, who's been talking about this issue in a little different context. That said, this case, and I'm going to be making a personal visit to Merced, I think, before the next hearing, which is June 8th hearing, which is on a Friday, and that's going to be the hearing on the motion, which he should win because the DA hasn't responded, and they now haven't done so timely, have they? That's a real problem because you go into court and you say, hey, we have this objection and that objection. What does the black little bastards sit back there and lean in their chairs and tell you so condescendingly? Failure to object timely is fatal. How does that not work both directions? If you figure that one out, please let me know. I'd love to hear it. But there are so many issues here, and it looks on paper like small issues, but they're not, and the Supreme Court gets it. Okay, there's been cases that have gone there, as I mentioned, the case called Thompson v. Louisville, a $30 fine for loitering in a cafe while waiting for a bus, and the court, in taking the case, written by Hugo Black, one of the reasons he's in my top 10 justices, and almost everyone else's top 10, and Hugo said in taking the case, the issues raised are small, but the constitutional magnitude is very great. He didn't say it exactly that way, but they got it. That what was going on there, if they were to permit this to go on and let a guy get convicted of an infraction on no evidence, this is what the court wanted to stop. And this is how we're going to plug it into them to do it in our cases too. They also say in the rules of guidance, capable of repetition yet evading review. And the evading review part comes for two reasons. One, none of their Supreme Court bar attorneys are going to raise issues like this, even if they're asked to do it. Number two, the court has made a career over the last 80 years, if not more than that, of not doing their sanctimoniously self-proclaimed job to say what the law is. That's what we want the bastards to do. Ask the right questions, the right status, the right court. 3 strikes, you're out of there. That's what we need to do, and this Merced case may actually get us there the first week of October of this year. There won't even be a need for a hearing, although I'm going to tell them in the moving papers, if you want me to come, I'm going to come. And we'll see. That's going to be a really interesting confrontation, because I'm going to stand up there, and all the meek attorneys go in there and they stand up in oral argument. May it please the court. Hell no. May it please the American people. That's the kind of attitude that we need. And by the way, I'll be talking more about attitude before this video session's over. Pay close attention. You're going to love what you hear about that one. Well, I've gone on a little bit long here, but I just wanted to get you up to speed on Merced. This is the Miracle in Merced Part 2. I just can't stand how good this is going to be. You're going to love it too. Hopefully have more on my upcoming talk show appearance on May 24th. Thank you.